Good afternoon, welcome. You are tuned in to WRFG here at 89.3 FM in Atlanta. My name is Diane Mathowitz. I'm a retired auto worker and one of the co-hosts of the program. Paul McLennan is also here, retired ATU member. We have another super show today, and so please stay tuned for the whole hour. We want to make sure that we thank everybody who turned out yesterday for the WRFG Carnival of Cultures fundraiser event. Besides raising money, we raised a lot of fun. We had a really good time, and we'll be talking more about it later in both. This show, probably you've heard about it on every program today about what great fun it was. I do want to make sure that we always announce that the opinions that are expressed on this program are not necessarily those of the Board of Directors, staff, or volunteers here at WRFG. The song that always starts the Labor Forum off is by John Fromer from his CD entitled The Same as That Particular Cut, which is We Do the Work. Here on the Labor Forum we talk with, about, and for all the people who do the work, not just in this city, in this state, in the country, but around the world, who make all the difference, who make everything move, who produce everything, and are the reason that society functions. So this program is always dedicated to workers everywhere. We're going to start off with our initial segment that opens every program, and that is the labor headlines. One of the purposes of the labor headlines segment to the program is to confirm one of our central beliefs, that workers and their communities are in struggle for justice and respect everywhere, and so often against the same corporate entities. So here is the news from the small South African country of Lesotho. Starting tomorrow, hotel workers, members of the National Union of Commerce, Catering, and Allied Workers Union are launching a month-long strike for higher wages. They work at two hotels owned by Sun International, the two swankiest in the country. And this is a small country which is landlocked and surrounded by South Africa. For those of you who were involved in the anti-apartheid movement, you might remember Stephen Van Zant's song, Little Stevie, called Sun City. Ain't gonna play in Sun City no more. That supported the cultural boycott of South Africa. Well, this is the same company that operated that resort that attempted to lure top-name entertainers from the U.S. to perform for apartheid. The 402 workers demanded a 9% wage increase in a country where 40% of the population earns $1.25 a day. The company countered with a 5% increase, but eliminated the meals and night transport currently provided. So in other words, give with one hand, take even more away with the other. During the months of negotiations, Sun International sold its 47% of its shares to a company called MINT, or M-I-N-T, Minor International Public Company, which will take over operations in February 2015. This company operates hotels such as the Four Seasons, St. Regis, Marriott, and others in 20 countries. Sun International Management has announced that it will lock out workers beginning today so they cannot disrupt operations on Tuesday, the first day of the strike. That's the news from around the world. Last week there were two important rulings by the NLRB, National Labor Relations Board. On December 15th, the board confirmed that employees can use work email during non-work periods for union-related communications. Mutual issues such as wages, benefits, work schedules, and other conditions of employment are permissible subjects for workers to discuss on their work email. This is recognized as a major plus for worker and union organizing. The second decision is in reference to McDonald's. On December 19th, the NLRB designated the multi-billion-dollar fast food corporation as a, quote, joint employer, close quote, of the nearly 14,000 franchise restaurants. This is an important ruling in the effort to win a national agreement for McDonald's workers. The board found 86 cases of unlawful conduct violating the rights of employees to openly seek better pay and working conditions stemming from their employees taking part in the National Fight for 15 and a union campaign. The violations included firings, reduced hours, threats, surveillance, and discriminatory discipline. Hearings will be conducted in March to determine any fines or punishment for McDonald's. And in closing, on behalf of the Labor Forum team of Paul McLennan, Tamika Atkins, Ozzie Ibrahimi, Christopher Hollis, and myself, we extend greetings to all workers and your families as you celebrate the many forms of festive gatherings during this winter holiday time. While some will have days off from work, many others will be on the job. We thank you all for doing the work that keeps everything going. And that's our labor headlines for today, December 22nd, and we're going to move right into Paul's labor history. What you got for us today, Paul?
Thanks, Diane. On December 25th, 1904, farm worker, labor leader, and Asian American civil rights activist Philip Vera Cruz was born in the Philippines. Cruz embodies the story of the Manong generation, the first wave of Filipino immigrants who came to the United States. Growing up in the Philippines, he undertook some farm work there, which he described as much easier than the work he would later do in California. In 1926, Vera Cruz moved to the U.S., where he performed a wide variety of jobs, including working in an Alaskan cannery, a restaurant, and a box factory. In the 1950s, he moved to California, became a farm worker, and helped bring together small groups of Filipino farm workers. This led to the formation in the 1960s of the Agricultural Workers Organizing Committee, which focused on adding members to the National Farm Labor Union. The organizing committee, composed mainly of Filipinos, engaged in a series of strikes in the California towns of Coachella and Delano. Philip Vera Cruz described the start of the Great Delano Grape Strike. On September 8, 1965, at the Filipino Hall in Delano, the Filipino members of the Agricultural Workers Organizing Committee held a mass meeting to discuss and decide whether to strike or to accept the reduced wages proposed by the growers. The decision was to strike, and it became one of the most significant and famous decisions ever made in the entire history of the farm workers' struggles in California. It was this strike that eventually made the United Farm Workers, the Farm Workers Movement, and Cesar Chavez famous worldwide. Following the strike call, the growers attempted to bring in Mexican-American workers, some of whom were affiliated with the National Farm Workers of America. Cesar Chavez, Dolores Huerta, and other leaders of the National Farm Workers of America met with several National Farm Labor Union organizers, including Vera Cruz. Together they decided that both unions would strike against the grape growers, an action which eventually led to both unions joining to become the United Farm Workers. The new union debuted in August 1966 and continued the strike into 1970. The union soon began a decade-long effort of strikes, boycotts, and other labor actions in its efforts to gain recognition and better salaries and working conditions for farm workers. Vera Cruz resigned from the United Farm Workers in 1977. That year, Cesar Chavez traveled to the Philippines to meet with Ferdinand Marcos, whom Vera Cruz saw as a brutal dictator. Vera Cruz continued to live in the San Joaquin Valley of California after his resignation, and remained active in union and social justice issues for the rest of his life. He died at the age of 89 in 1994 in Bakersfield, California. In an oral history, Philip Vera Cruz summed up some lessons from decades of organizing. Commenting later about the issue of immigration, he said, "New immigrants who will compete with the workers already here are arriving every day from the Philippines, Puerto Rico, the Arab countries, from Jamaica, and especially Mexico. Third world countries have been exploited so much by the multinational corporations that their people, moved by extreme poverty, leave their home countries to seek work in an industrialized country like the United States. The multinationals suck the wealth out of their homeland like a vampire sucks blood. And these same businesses here greet these new immigrants with open arms. When the present group of workers here start to get organized and win some of their struggles for better wages and benefits, then the big agribusinesses here in California, with the help of the government, try to bring in new groups of workers. About his experience in the labor movement, he said, "I learned about people, about struggling to improve your life along with your fellow workers. I learned new and important things about this country, about economics, about change, and about life. And I received these valuable lessons from my association with the farm workers movement." The success of any positive change in this country depends on the strength of the workers, and the organizations that hold the workers together are unions. "I see life as a continuous progressive struggle," he added. "A group of people struggle to survive. They get older and then they're gone. But the next ones will come together and solve some of their problems. They'll align themselves with others and make advances that the previous generation wasn't able to accomplish. If I could inspire one or two young people to be successful by hearing my story, which you know by now is the general story of all early Filipino immigrants to this country, if this one or two young people might turn into someone who could help change history, why, that would be good. If more young people could just get involved in the important issues of social justice, they would form a golden foundation for the struggle of all people to improve their lives. I have always believed that the future belongs to the younger people."
Thank you so much, Paul. And that is such a perfect segue to our two guests that are seated here in the studio. I want to introduce to our listening audience, and I want to remind people again that you are able to listen to the Labor Forum of course, on your radio, 89.3 FM. You can listen online at wrfg.org. You can use your mobile device and listen on the many apps that are available. And especially, the Labor Forum has also got its own YouTube channel, and you can watch. And if you are watching right now, you see seated right here two sisters. I want to introduce Mo Morgan. Hi, Mo.
Hi.
And seated next to her is Shakia Pinnex.
Hello.
And the reason we are so excited that they're here is because these are two of the young women that did this really bodacious action this past Saturday. And it's part really of the whole national movement that has arisen following two specific cases of police impunity where they were able to kill unarmed black men, first in Ferguson, Michael Brown. Well, actually, it was first Eric Garner was actually killed first, but the rulings of the grand juries came the other way. So first we heard that the grand jury in Missouri was not going to indict that police officer on anything, and then even though there was a video that the whole world could see, the police were not indicted in the killing of Eric Garner. And there has been a national uprising that has taken place. And actually it's more than national, because it is actually international. And these two young women here are part of that movement, and they are part of this emerging leadership that was really just addressed by the report that Paul gave about how a union organizer who was so influential in changing the status of farm workers projected a constant need for new leadership to come forward. So we're thrilled you're here.
Thank you. Thank you for having us.
And so I guess I'll just start. I always ask anybody who comes here, well, so how did you get involved? What motivated you? Why are you doing this? You want to start, Shakia?
Sure. I've always been really interested in social issues and social justice. I'm currently getting my master's in criminal justice, so I've always been interested, but when Eric Garner was killed, and then John Crawford, and then Oscar Grant, and then Michael Brown, it was just so many people in a short amount of time that I just I felt the urge that I have to go out and I have to stand up for these people who've been killed, because they can't do it anymore, and I can't just sit in the classroom. I have to be out there. I have to find the people who are in the streets and willing to sacrifice their time, their energy, their money to stand up for social justice. So around like the beginning of August, that's when I started like just going out and reaching out to the people who were just out in the streets protesting at that time. And then we started organizing, and I just started meeting new people.
And here you are.
And here I am.
And you're seated next to Mo, so Mo, what's your story?
Yes. Well, my family, my father has always been involved in social justice work, and sort of has instilled that in me from a young age. And so, like Shakia said, with the 28 hours study, the evidence coming out that every 28 hours, a black man, woman, or child is killed by the police. It's just that fire, you know, comes up. And so, like Shakia, I went out and, you know, to the streets, and I started meeting people who were organizing, and having found that community and the encouragement to really get in there, to really get involved and, you know, keep the movement going. So, yeah.
May I ask how old each of you are?
I'm 23.
And I'm 25.
Well, so obviously, okay, so all across the country, we can just talk about tens of thousands of people in New York City 2 weeks ago, in Washington, D.C., in city after city, large and small, people doing die-ins in malls, in the streets, blockading traffic on interstates, everything. Could you two comment on why you feel the necessity and or the importance of doing those kinds of actions? People may think of protests, you know, that you go to a little rally in the park and you have a lot of speakers. But these are things that directly go to where people are. Could you both talk about why you feel this change, or maybe not change, but this this type of location and this type of action is what is needed, as opposed to maybe some other forms of protests that have happened in the past?
Yeah, I think these types of direct actions do not allow people to ignore us. Being in parks and getting permits and everybody knowing what happened, they can easily avoid areas that we're at. But actually bringing our voice and our issues directly to where you are, whether you're driving home from work, you're trying to shop during the holiday season, you can't ignore us. And when we stop traffic and we halt people, we make people say, hey, you have to listen to what we have to say, at least right now.
Do you have a comment too on that, Mo?
I would agree with Shakia, and we went to Peachtree and Linux specifically for that reason, to reach people who don't come south of town, who don't come to the rallies at Underground, who you know, may not be connected to the networks that we are online, who have the privilege of ignoring these actions and things taking place, or the rallies taking place. They can't ignore the actions when we bring that to them.
So both of you were arrested, is that correct?
Yes.
Well, I'm talk about that, because one of the things that's seemed very apparent in the last several weeks is that the police authorities are, I can use a word, messing with the process, in other words. So could you both talk about your experience, what happened Saturday after you were arrested?
Well, there was a bit of the runaround, of course, as somewhat, when we did arrive, we were initially taken to a precinct and held there for several hours, and when they finally took us to Rice Street, it took them quite some time to process us. I believe we sat there for about 2 hours before they even began booking us, and so that in turn delayed the processing of our bail. You know, so we were there for 12 hours, you know, after the fact.
My understanding is that the police weren't letting supporters into the building, into the parking lot, wouldn't answer questions about what your charges were, wouldn't tell people where you were.
Yeah, like we asked when we were actually in Buckhead for a couple hours, we were like, can we please like use the phone, because initially we thought we were going to be going to Atlanta Detention Center, so we knew that's where our supporters were going to be, and we were like, can we, once we found out that they had upped the charges from just like traffic violations. We were like, oh, we're going to Rice Street. Like, can we please just have one phone call? And it wasn't until we were booked that we were allowed to have that phone call to let people know where we were.
Oh, so what are your charges?
We got pedestrian and roadway, obstruction of highway or street, and unlawful assembly. So they were really stacking the charges against us, and that, you know,
Increased how much the bill was.
right, increased how
Bond
much
was.
the bill was, yes.
Well,
I had a question. When we talk about this issue, the names that come up, Trayvon Martin and Michael Brown and Eric Gardner, but also that women of color are also affected by this issue. Could you talk a little about that?
Yes, we made the we made it a point to evoke the names of Tarika and Rakia and Ayana and Katherine Johnson, who was you know, who happened here in Georgia, you know, and so we wanted to make a point that and that that women of color also face violence from the police, and that to bring that up is not a divisive thing. Like, we need to be sure to pay attention to all Black lives in this movement.
isn't that what your banner said that you had down on the ground?
Yes, it did.
So, okay, so that action generated a lot of national publicity. Then there was the situation in the Mall of America. I'm from Minneapolis. Mall of America in Minnesota, where 3,000 plus people went in. There had been an action Friday at Perimeter Mall. There was another one Sunday. Do either of you want to talk about the other one here in Atlanta on Sunday?
Well, I didn't attend that one, still recuperating, but it was the Power of Our Dollar March, and I believe it was concentrated in the same area that we were. They didn't obstruct the roadways. This was a moving protest, and then at the end there was a call to buy black, and using the power of our dollar as far as economically pressuring the government and, you know, other people in power to really pay attention.
So, this has been intense. Sometimes there have been, I remember one Saturday, I think there were 4 different demonstrations one Saturday a couple weeks ago. And very clearly there was planning that had to go into the action that you all did at the corner of Peachtree and Lenox. And I assume that you are not going to reduce the amount of activity. Is there anything that you can let our listeners know about, or a website or information, how they can get engaged? You know, one of the things is, yesterday we were having our WRFG event at the Solarium, and churches in the Decatur area, we saw them. They were marching in the little park just a block from where we were doing this fundraising event, and we knew immediately when you saw the signs that it was members of the various churches in the Oakhurst neighborhood who had come together for another demonstration, another visibility effort to say that all Black lives matter. So is there any information that you want to share with our listeners about how they can get engaged? Like I said, websites, you have weekly meetings, any of those things?
Yes, I'm a member of the Generation Y Project, and we have meetings every Thursday at 7 at 60 Walton Street. We won't have a meeting this Thursday, but we will resume meetings January 1st. Also, you can text SOAR, S-O-A-R, that's, it means Southerners Organizing Against Racism, to 69866. And you can get information on what the Gen Y Project is doing. And we'll also have a National Day of Action coming up on January 15th, so be on the lookout for that.
Thanks a lot. Do you have anything more from your group?
I would recommend following the Shut It Down ATL Twitter. That is a coalition of several organizations, the Gen Y Project, Southerners on New Ground, or Sister Song, and It's Bigger Than You, yes.
Well, I have to say, for somebody who's had a chance to go to some of these demonstrations, that I have been just so wowed by the, both the energy, the political astuteness, the competency, the passion of all of you who have just done extraordinary work here in the Atlanta area to bring this subject. And it is not as though there have not been uncountable numbers of protests every time one of these police killings has taken place. And there have been so many here in Atlanta over the years that I have lived here. And so what I see is the absolute unwillingness to let this go away, this issue go away. And I want to really congratulate both of you for what you're doing, and I want to thank you so much for being on the air here on WRFG today.
But thank you for having me.
Yes, thanks for having us.
So folks, we are going to take a little short break, and please do pay attention to this message from WRFG. And when we return, we're going to expecting a call from Emily Martin. She is the lead counsel for the National Women's Law Center, National Women's Law Center. And we will be discussing a very important case that's before the Supreme Court concerning pregnant workers. It's a case that comes out of UPS, and of course we all know the headquarters of UPS is right here in Georgia, so a very important issue. Please stay tuned. We'll be right back. Welcome back. You are tuned into the Labor Forum here on WRFG 89.3 FM in Atlanta. And so we are just about to start our interview with Emily Martin. She is with the National Women's Law Center. And hi, Emily. Thank you so much for calling in.
Sure. Thank you so much for having me.
Well, we're excited about this interview because, of course, UPS is headquartered here in the Atlanta metro area. And we have had many Teamster members on this program, the Labor Forum, on other issues related to not just UPS, but all of these companies that both deliver, where they're drivers, etc. So if you wouldn't mind, first off, explaining, if there's to our listeners, what is the background of this case? It is about the situation of pregnant workers, but how did it happen? What is it?
Sure. So Young versus UPS is a pregnancy discrimination case. Peggy Young was a UPS driver for many years. She did what was called air deliveries, which means she would deliver packages that came by airmail in the morning, so relatively light packages actually. And when she became pregnant, her medical provider told her that she should avoid lifting more than 20 pounds during her pregnancy. So Peggy Young went to UPS and said, I'm perfectly comfortable continuing to do my regular job because I don't have to lift heavy objects very often in my job. Or I could do light duty. That would be fine too. Either one is fine. She figured light duty would be available because UPS had a policy of giving light duty to lots of people. They gave light duty to people with on-the-job injuries who needed it, to people with disabilities as defined under the Americans with Disabilities Act who needed it. Even people who'd lost their commercial driver's licenses, whether for health reasons or because of a DUI, all those people were eligible for some sort of reassignment to address their needs. But UPS said to Peggy Young, no, sorry, you can't continue to do your current job because you're too much of a liability. And we're not going to give you light duty either because you don't have an on-the-job injury, and you don't have a disability, and you haven't lost your commercial driver's license. You're just pregnant. And so what happened to Peggy is that she had to go on unpaid leave for the duration of her pregnancy, and she lost her UPS-provided health insurance. Never a good moment for those things to happen, but it's an especially difficult moment when you're expecting a child, and so it was a very stressful time for her. So the question for the Supreme Court, which is considering the case now, is whether UPS violated the Pregnancy Discrimination Act, which has been the law since 1978, when it said it would make accommodations for all these other categories of workers who had some restriction in their ability to work, but not for pregnant workers who had a restriction in their ability to work.
So what was the year this case first started? When did this happen to Peggy?
It happened a while ago now. It was back in 2006 when this happened to Peggy. So it's taken a while to get up through the courts. The wheels of justice definitely turn slowly.
Okay, so we have, there's been news about the hearing that took place before the justices, and the expected date of when they'll make a decision is not known. Do you have any information about the difference between how the laws and regulations and protections afforded pregnant workers in the United States versus any other industrial country or the world in general?
Well, there are definitely other countries that explicitly say that employers have to make accommodations when workers need them because they're pregnant. The law here, we think, requires it. We think Peggy Young is in the right in saying that UPS has to provide accommodations to her because it provided accommodations to others. But the law is a little less explicit. What the Pregnancy Discrimination Act here in the United States says is that employers have to treat pregnant workers the same as they treat those who are similar in ability or inability to work. And so the question the Supreme Court is struggling with is what that means. Seems to me the law is clear, but unfortunately some of the lower courts have disagreed, so we're hoping the Supreme Court does the right thing here.
Do you know anything about what the pregnancy laws are in, I don't know, say France or Germany or any of the other industrialized countries that the U.S. Is, I guess, in competition with?
Yes, I think I just read recently, and I hesitate to say it too firmly, I believe it was Australia is an example of a country that explicitly says you don't discriminate on the basis of pregnancy and you provide reasonable accommodations for pregnant workers. I think that in other industrialized countries this is an accepted way of doing business. And luckily in the United States, we're seeing more and more states adopt the same explicit policies, saying really clearly that employers have to make reasonable accommodations when pregnant workers need them. So just in the past couple years, we've seen a lot of states adopt these laws: New Jersey, West Virginia, Delaware, Minnesota, Illinois, and I think we'll continue to see that in the coming years, which is definitely encouraging.
Given the composition of the court and any decisions they've made, do you have any decisions they've made related to similar issues? Do you have any sense how they will rule?
Well, I will be frank and say, given the composition of this court, we're always nervous when the court takes up a question involving workers' rights, employee rights, and women's health. This court does not have a great record on those issues, so we always look to this court with some trepidation. That being said, I think one of the things in Peggy Young's favor is that the language of the Pregnancy Discrimination Act is so clear and addresses her situation so directly, it would seem, when it says that employers have to treat pregnant workers the same as they treat those who are similar in ability to work. You know, a lot of the conservative justices talk a lot about caring about what the law says and the statutory text being really important. And if that's the case here, then the statutory text really says that UPS has to provide accommodations to people like Peggy because they provided accommodations to other people who had similar limitations.
I wanted to ask a question because, I have two questions, but let me first ask, because you just stated that a number of states have gone ahead and made it clear that in their state, corporations have to abide by providing light duty or comparable jobs for people who have other reasons that they need light duty. So what would the impact then be if the Supreme Court does not rule in Peggy's favor?
Well, if the Supreme Court rules against Peggy Young and does so through, a decision that says it's really not appropriate to compare pregnant workers with these other categories of workers and determining whether an employer has to provide accommodations, that hurts people, women across the country. who will too often be forced to choose between their job and their health if they ask their employers for some sort of temporary accommodation during pregnancy and are told no. Now, as I said, there are states where pregnant workers will still have the right to reasonable accommodation. Unfortunately, at this point, it's the minority of states. There are states where that right is clearly set out in state law. But obviously, if it's a patchwork and it depends on where you happen to live, that's a lot less protection than a clear federal standard.
Now, my understanding from reading about this case is that Peggy actually stopped working for a considerable period of time. Am I right?
Yeah, so the result of UPS's refusal to let her continue to do her job or to do light duty, what she had to do was go out on unpaid leave basically for the duration of her pregnancy, which was not what she wanted. She really wanted to be able to work and just wanted the basic accommodations that UPS was providing to other people with similar restrictions and similar limitations that would allow her to continue to work.
And keep her insurance.
And keep her insurance and keep her income. And it was the absence of those things which really made her pregnancy, unfortunately, stressful time.
And so this other question I want to ask. So if, I just lost what it was. I'm going to let Paul talk.
If, considering the fact this is a workforce represented by a union, is there an opportunity here for this problem to be addressed through contract negotiations in terms of language?
Definitely addressing pregnancy accommodations is a thing that can be done through collective bargaining agreements, and in some instances has been done. That's how these protections for on-the-job injuries and for people who lost their commercial driver's licenses were put into place. So absolutely, there's an opportunity for strong union representation to secure these protections no matter what the court does. And that is the case both at UPS and lots of other places.
For the amount of money which I can't imagine that the company is spending to fight this woman, what's their motive? I mean, is there that much money they think that they would lose? Is it a liability concern, or why are they so adamant about this?
You know, it's mysterious, and frankly, it's even more mysterious because in November, the UPS announced when it filed its Supreme Court brief that it was going to, what it called, voluntarily start accommodating pregnant workers starting in 2015. So UPS has announced that it's going to start doing what Peggy Young wanted. UPS says they've decided it just makes business sense to adopt this policy. They're arguing that they still didn't have any legal obligation to provide these accommodations. They should still win in court. But the fact that they've made the decision to provide these accommodations going forward to all pregnant workers who need them really does make it a little unclear to me why they've chosen to fight this all the way up to the Supreme Court. Though I do think the fact that they have made the call that it just makes sense for their business to provide accommodations is a real model for other employers.
That was what I was trying to remember. I was going to ask you the exact same question that Paul just did because that was just so baffling when I read about the case being heard, and then I read the paragraph that said UPS is fighting this case, but they are voluntarily totally changing their policy. Do you think that they are in fact sort of the I don't know, that the other corporations, Chamber of Commerce, I don't know who, is still wanting them to fight that so that it doesn't become a Supreme Court decision, so that it becomes voluntary? Can that be it? I mean, is that who's backing them up? I mean, otherwise they look as foolish as they can be.
Well, I'm sure that the business groups like the U.S. Chamber of Commerce that weighed in on UPS's side in the Supreme Court, yes, they don't want a legal rule that requires businesses to do this. They want this to be up to businesses to decide whether they want to do it or not. But it is really fascinating that UPS has made the determination whether because it's concerned about public relations or whether because it's really looked at its workforce and determined, it doesn't make sense to force these women off the job. They are valuable employees, and they should be doing work for us. They want to work. We should let them work. It's really fascinating that that's the conclusion UPS has come to, even while it is spending all this money and energy fighting against the idea that there's some legal obligation to provide those accommodations.
May I ask a question? What will Peggy Young get if, let's say, the Supreme Court rules in her favor? What happens?
If Peggy Young wins in the Supreme Court, what she'll get is a chance to bring her case to trial, a chance to present her evidence to a jury, and ultimately a chance to win damages to make her whole for the money that she lost as a result of UPS's pushing her off the job and off of her insurance, and some sort of damages. But it would be a chance to have her case heard, is what she's fighting for.
Now, does she currently work for UPS, or has she gotten a different job somewhere else?
She is no longer with UPS. I believe she's stayed on with them for some period of time after the events in question, but she's not there now.
Okay. So, Emily, now, I wanted to ask a question now about the National Women's Law Center. So how is it that you are engaged in this case in particular? And what other cases are there that we should know about on this program that you are involved in?
Okay. So we at the National Women's Law Center have been very engaged on the issue of pregnancy discrimination and pregnancy accommodation over the past several years. And thus have been sort of watching this case since it was at the trial court level. Specifically with the case in the Supreme Court, we filed a brief on behalf of 123 members of Congress in support of Peggy Young, talking about what the Pregnancy Discrimination Act was meant to do and why it was intended to provide relief for pregnant workers in these situations. And we worked closely with a broad coalition of groups supporting Peggy Young and supporting accommodations for pregnant workers, both in the courts and in Congress and in state legislatures. And then more broadly, there are various cases that we are watching this term in the Supreme Court, including not just this one, but the Affordable Care Act case that the court is hearing this term, King versus Burwell, about the availability of subsidies for folks who buy health insurance on the federal exchange, an issue that's very important to women, given the importance of the Affordable Care Act subsidies to women getting the health care that they need. We're also watching a case called EEOC versus mock mining, which goes to the EEOC's enforcement powers to enforce anti-discrimination law, and whether employers will be able to basically throw up new obstacles in the way of EEOC enforcement of anti-discrimination laws. Those are a few of the cases we're watching. We're also waiting to see if the Supreme Court takes on another case addressing the birth control coverage requirement under the ACA as it applies to religious nonprofit employers.
So I'm going to just ask some questions about your organization. So is it that women who find themselves discriminated against on the job contact you, or is it that you are looking at the cases that they independently file and then you support them by submitting a brief?
Well, a little bit of both. While we don't represent many individuals in their own cases, we do so occasionally. So, for example, just last week we represented a woman who works for Walmart in bringing a charge of pregnancy discrimination against Walmart. So there are individual cases where we represent folks who have experienced discrimination, but we also do a lot of work supporting cases that are already in the courts and doing policy work, making sure that here in Washington, D.C., that the laws are being enforced appropriately by federal agencies, that they are being interpreted appropriately, and trying to get good laws through Congress, so that's perhaps easier said than done these days. So a mix of litigation and policy efforts.
Is it your experience in looking over these pregnancy discrimination situations across the country, that it more likely happens in workforces where women are the predominant workers, or does it more, because I would think UPS actually has relatively few in terms of the tens of thousands of workers they have.
Yeah.
Yeah, so who's the more discriminating against type boss?
My sense of where these cases are most likely to arise are a couple places. First, I think these sorts of cases are more likely to arise in occupations where women have traditionally been underrepresented. So jobs like truck driving or police work or corrections officers are examples of the sorts of occupations where we see these sorts of claims fairly regularly. And I think one reason for that is because often in these workforces there's some hostility to the idea of women doing the job at all. And so hostility toward pregnancy is just sort of part and parcel of that broader hostility.
Yeah.
And we also see a lot of these cases arising from low-wage jobs, which may be often are majority female, but in general are jobs where, frankly, workers' rights just are often ignored by employers. So whether that's retail work or nursing assistants or cleaners, those are jobs where we also see these sorts of stories where kind of the knee-jerk reaction to a worker asking for some temporary accommodation is just to be told no and to be pushed off the job. Those are the places where we hear these stories the most.
Could you say what an ideal policy, I know you mentioned Australia, but if we wanted to, we talk a lot about human rights on this program, what ideally would be the policy that you would like to see this country follow in terms of this issue?
What I would like to see this country do is basically apply the same standard that is already applied to folks with non-pregnancy related disabilities, which is that an employer has to make reasonable accommodations unless it is some sort of undue hardship for the employer to do so. That would mean that if an employee has some sort of temporary limitation arising out of pregnancy, that the rule should be clear that what happens is the employer and the employee work together to figure out if there's a way to accommodate it. And if there is, then that's the employer's obligation. I think that should be the standard that applies here. And it's not a novel standard. Again, it's the exact standard that we are already applying for disabilities.
And another question I had is about the Family Medical Leave Act. What's the relationship between that and is there any overlap around the question of pregnancy?
Well, there is. The Family Medical Leave Act for workers who are covered by it does provide a right to up to 12 weeks of unpaid leave for childbirth or for a serious medical condition, which can include pregnancy. If, for example, you have to go out on bed rest because of pregnancy, you may have leave rights under the Family Medical Leave Act. And that is a critically important right for lots of workers. One problem we see, though, is employers refusing to make the accommodation that will let the worker stay on the job and do her job, instead pushing the employee off onto FMLA leave early in her pregnancy. So she uses up those 12 weeks before the baby's even born, and then she loses her job because the employer won't let her come back. So that's the way that we've seen employers basically abusing the FMLA by forcing women onto leave when actually a simple change at work would let them continue to work, and that's what they want to do, is continue to do their job.
I have another question. I've been many times in some of the big box retail stores, and again, this is a mostly women workforce and low wage, and I've seen pregnant women and they're not even given a mat, to stand on for hours or a stool to sit on, and I think to myself, now, what would this cost? Why can't this be done? Is there anything with the Pregnancy Discrimination Act that has any bearing on such simple things as not even changing the job, just making the job less stressful for somebody who's undergoing pregnancy?
Well, what the Pregnancy Discrimination Act says is you have to treat pregnant workers the same as other people. So if you're providing people a stool if they need it because of, say, a leg injury or a back injury or some other medical condition, you providing it to the pregnant worker who needs it too. It's an equality standard, and it's basically looking to see, well, how do you treat other sorts of medical needs, treat medical needs arising out of pregnancy the same way.
I see. So if this big box store doesn't give a stool or a mat to this other person, then they don't have to give it.
That's right, but it's also true that the big box store probably does have to give a stool to various people who have leg injuries and back injuries because the Americans with Disabilities Act requires them to do so. And so given that they probably, assuming they're not just violating the law across the board, which is always possible, but assuming that they're following their legal obligations under the ADA to folks who have these sorts of injuries, that really has implications for how they need to be treating pregnant workers as well.
So I guess it's a final question. This is a program that is called the Labor Forum, and we deal, largely with all the issues that are important to working people and their families. So what is your understanding of a favorable Supreme Court decision? How many women workers would this potentially impact in a good way?
Well, I think a favorable decision would have a really large impact. We don't have perfect numbers, we don't have great numbers on how many pregnant workers seek accommodations during their pregnancy and are denied them at work. But the best estimates we have suggest it might be 250,000 women a year. And, for women who are put in this situation of having to choose between their health and their job when their employer refuses to make these sorts of accommodations, it's really a choice nobody should have to make.
Exactly.
And a victory for Peggy Young would really be a victory for all those women.
I want to thank you so much. Listeners, you have been hearing Emily Martin with the National Women's Law Center out of Washington, D.C. And I found this to be a really informative discussion. I want to thank you so much for making the call here to WRFG and to the Labor Forum. Is there any kind of contact information or places that you would recommend that people could go to, either on a website or, I don't know, books or anything where they could find out more information, and also how to really follow what happens with this case?
Right. Well, definitely check out our website. We will keep you updated about this case and this issue, and it's www.nwlc.org. You can find a link there that says I Stand With Pregnant Workers, and if you click through, you'll find lots more resources about the case and the issue. And definitely we encourage people to tune in and follow. It's a critical issue for so many women and families.
Thank you again. Thank you so much.
Thank you.
Thank you, Emily.
Bye-bye.
Bye. All right, that concludes today's episode of the Labor Forum. And it is just a couple days before some people will be taking off on holiday trips. Maybe you have got the day or the week or a couple days off to spend with family and friends. Please do be safe. We will be back again next Monday, and that is the 29th, our last show of 2014. I have to say, Gary Washington called me after last week's show, and I couldn't remember how many years I'd been doing this. He clarified it. I started doing this in November 2010, so 4 years, and the time has flown by, and I've enjoyed every minute. So I want to say bye for now, and I want to thank Paul again for doing another great labor history and being a great co-host.
Thanks, Diane.